All right, White versus Politis, 22-30033. All right, why don't you go ahead and now, are we ready?
I'm ready, Your
All
Honor.
right, and your appearances?
Eric Bradstreet on behalf of the plaintiff, here with me is Ms. White.
Good afternoon, Judge. Jeffrey Partlow, here on behalf of the defendants. With me is Francis Carroll, as co-counsel for the defendants.
All right, motion to dismiss, right?
Yes.
Statute of limitations problem,
Yes.
and it's really not malpractice, is it?
It is not.
All right, go ahead, give me your argument.
Thank you, Judge. You hit the entirety of the motion in those two sentences. Plaintiff brought this case. It's a motor vehicle accident. My clients were hired as counsel. They settled that case in March 2017 for $350,000. There's a contingency fee paid.
Right, 30%.
Yes, 30%. So this case was filed more than 4 years later. The claims you have before you, there are 5 of them. There are not many differences between the current complaint and the last complaint, other than their addition of new claims and a couple of allegations. The first 3 are different varieties of legal malpractice. The 4th is breach of fiduciary duty, and the 5th is unjust enrichment. So the first issue, Judge, you said this is not a legal malpractice claim. The allegations
You
are
would have made a good unjust enrichment claim if it was within 4 years, right?
they would have a claim that's not, yes,
Probably would have been a good one, too.
it would have been a claim.
All right.
So to address in advance an argument raised in response, the position is not that there is no legal remedy for this type of claim. The argument is that, number one, it is not legal malpractice. We cited cases for that very position.
There has to be a bad outcome.
Correct, there has to be a bad outcome. Here you've got the elements, the employment, the neglect of a reasonable duty, and that is the causal connection to damages. Here the alleged neglect of a duty is a technical deficiency in the contingency fee agreement. And if you say, well, if that,
I wouldn't call it a technicality.
a deficiency, we'll say,
All right.
that's the allegation. If that alleged negligence or deficiency does not occur, the fee would be the same. In other words, there would be no damages if what they're claiming was done wrong wasn't done wrong. There is no legal malpractice claim in the state of Florida for an alleged improper attorney fee, whether it be an overcharge of fee or whether it be you have a contingency agreement that is allegedly.
Well, what happens if there's a bar complaint?
If there's a bar complaint, it's
Don't
irrelevant.
they say that that contract's no good, and he'd only be entitled to his hourly rate?
Case law, which generally comes up when an attorney seeks to enforce a contingency fee agreement. If the agreement is void, then the attorney is
The case law
entitled.
is never in the opposite direction, is it?
I have never seen one.
The case law is just in the direction where the lawyer's suing to get his fee.
Correct. Those are the only cases I have ever found. In that instance, if the contingency fee is void, then the attorney is still entitled to the reasonable value of the services provided.
Yeah, but what does the bar say? Doesn't the bar say you can't collect your fee? You can only collect the hourly?
Bar says, I believe you can collect the reasonable value of the services provided.
Well, that's an ethical rule, right?
It is, and the cases cited, I did not cite them for that proposition, but the cases say an ethical issue is not a claim for legal malpractice in and of itself. You have to have an alleged neglect of a duty that is the causal connection to damages.
So that's why the cause of action should be unjust enrichment, right? because he shouldn't have got the contingency fee under the ethical rules.
On-
And since he got he got that fee and he only should have got hourly, that additional money, since it's really not a contract because the plaintiff or the plaintiff's representative never entered into a contract,
That is the allegation.
it'd be unjust enrichment.
Under their theory of the case, assuming they are correct, it would be an unjust enrichment type claim.
So there really wouldn't be a breach of contract claim at all, would there? Because their claim really is, there is no contract.
Their claim is no contract.
Right.
So whatever the claim is, it is not for breach of a written agreement, meaning the longest statute of limitations we could have is 4 years. If you go 4 years from the date, March 2017, when the case was settled and paid, puts us in 2021. This case was not filed until 2022, which means the claims are barred.
And you're saying the discovery rule doesn't apply?
The discovery rule does not apply because this is not a claim for legal malpractice. The 95.11 in the context of a claim against an attorney, a 2-year statute of limitations applies regardless of the type of claim. So if you sue an attorney in malpractice or professional negligence, whether it's in contract or tort, it's 2 years with the delayed discovery rule. However, the facts we have alleged here, based on the cases that I've cited and just simply the elements of the claim, this is not a legal malpractice claim. And so you have no delayed discovery rule for the remaining 4 claims, or 2 or 4 claims, depending on how plaintiff wants to address it. All of those claims at most have a 4-year statute of limitation and they're barred. And that is the entire gist of the motion. We get into the detail on the cases, but it boils down to 2 things. One, this is not a claim for legal malpractice, which means count 1 and rule that counts 2 and 3 fail because of malpractice. But also because it's not malpractice, delayed discovery does not apply. It is not going to be disputed that this case was filed more than 4 years after the alleged injury. And because there isn't a delayed discovery issue, that these claims are barred as a matter of law. And so they should be dismissed with prejudice because no amendment is going to fix this. Plaintiff has also had many attempts well within what the 5th says you have to provide. And so we request you dismiss this case with prejudice because the claims as asserted simply are not legal malpractice as a matter of law and they're barred by the statute of limitations.
All right. What was okay, when's the starting date for your statute of limitations?
March 2017, based on paragraphs 15 and 16.
All right. What happened in March of 17?
The case was settled and $105,000 was paid on the contingency.
So that was paid in March of 17.
Yes, I believe so.
All right. And then, as far as Ms. White being the guardian, if she was brought in after 3 years, but before 4 years, she gets a year from when she was appointed guardian? As far as
She
the
does.
statute of limitations goes?
There is a tolling issue in the guardian statute once a guardian is appointed, but that only applies if the statute has not run at the time of the appointment, but the plaintiff's response makes clear they're not relying on that provision. They're relying on delayed discovery.
All right. The 4 years, I guess, occurred after her 1 year as guardian, though, right?
Correct.
Okay. All right. What's your argument?
Thank you, Your Honor. Eric Grassley for the plaintiff. One thing I wanted to hit kind of out of order as far as the statute of limitations goes is counsel ignores the just plain language of section 95.114B, an action for professional malpractice, other than medical malpractice, whether founded on contract or tort. We believe that this is founded on essentially a quasi-contract, either an applied in fact contract or an implied in law contract, because there's no doubt that Mr. Politis did act as Mr. Faust's attorney, even if he did not properly get the contract signed prior to the contingency occurring. So to kind of piggyback on that, Your Honor, although it is a federal case.
Well, aren't you just claiming that the damages is the fee? You're not claiming damages that Mr. Politis didn't properly settle the claim, right?
No, I mean, he did
And
some
you're not
policy
claiming that he
limits.
should have got $1 million instead of 350,000, right?
No, he got policy limits, so we're not,
So he gets the policy limits.
yes, sir.
All right, so a better result was not going to happen, correct?
Well, Judge, we do allege that,
I mean, as far as the overall settlement
as
goes.
far as the overall
Without
settlement,
talking about the legal fees.
as far as the
There
overall
wasn't
settlement,
going to be a better result than getting the policy limits, correct?
not that I know of, no, Judge.
All right, and you're not claiming there was, that there is one?
I'm not claiming there was some other policy out there or some
Okay. So
pothole.
the only damage you're really claiming is that he shouldn't be able to collect a $105,000 fee. He should only be able to get an hourly rate.
Yes, sir.
All right. Why is that malpractice?
Well, the reason it's malpractice, Judge, and we have alleged that,
Do you have a case that tells me that, that's malpractice?
Judge, we do have the Olmsted case, which was cited to you in our response. And the interesting thing about the Olmsted case was, although the reported decision does not say what count 2 was, essentially in Olmsted, there were 2 counts. One was for the alleged bad outcome, and the second count was for an illegal contingency fee.
All right, but you don't have a bad outcome here.
Right, but those two counts were considered by the court independently. The court did not look at whether there was a bad
What
outcome.
was the second count? What was the cause of action in the second count?
In count 2 of his amended complaint, Olmsted alleged that the contingent fee charged by appellees was excessive and illegal under Florida law, according to a void contingency fee contract. The reported decision does not say if he alleged it as a legal malpractice count
All
or
right,
as.
so they don't call it malpractice.
They don't, no, so they don't specifically call it malpractice, but the
What do they
idea,
call it? What is it? What actually is the cause of action?
the reported decision is silent, and it literally says a void and illegal
Because
contingency.
they didn't know what cause of action it was either.
And that may be why, but the reason the court dismissed it, the reason the court ordered summary judgment, not dismissal, wasn't because there's no cause of action for any contingency fee. It was
Or they
because,
asked for declaratory judgment to declare that the contingency fee was invalid.
no, Judge, they were asking for,
So besides
that demand the
unjust,
entire fee to be returned.
so besides unjust enrichment, you probably could have brought a declaratory judgment cause of action, trying to declare that the contingency fee agreement was null and void
Well, it might,
under the statute.
it might declare that, Judge.
So that's 2 causes of action that might have worked.
Right, but we believe, Judge, the unjust enrichment
Have you got a
does.
third possibility? I can't think of any others. Can you
We
think of a
alleged
third?
legal malpractice, and we alleged that there was
It's not
damage.
It's not malpractice.
We've also alleged that there's either an applied in fact contract or a quasi contract, an applied in law
Well,
contract.
that's kind of what unjust enrichment is, isn't it?
It's very similar to the implied in law contract. It's technically a little different than the implied in fact contract, to get deep in the weeds. But the point being is that a cause of action under the statute for professional malpractice, whether in contract
How
or
is this
court,
malpractice?
because a professional malpractice case, when you're going against your lawyer, your former lawyer, it is
I'll tell
always
you
a
what,
malpractice case.
you tell me what the elements of legal malpractice are. You got to spell them out for me.
Legal malpractice, if it's alleged as negligence, is duty, breach, causation, damages. If it's alleged as fiduciary duty, it's similar to that. If it's
Okay.
alleged as a
So
breach of contract,
what are you alleging the lawyer did wrong in representing his client?
alleging that he took a contingency fee that he either knew or should have known.
That's a contractual relationship between the two. That's not negligence.
If I may, I was discussing a case that we cited that, although it's out of the federal court, Materia versus Nussbaum, 95.11 was applied, including the late discovery rule for counts of breach of contract and unjust enrichment against the plaintiff's former lawyers. That's the Nussbaum 11th Circuit, the Southern District case in 2019. It basically says the 11th Circuit
All right, so you've got the discovery rule for unjust enrichment
in a federal case, yes, sir.
in a federal case.
Yes, but it's applying 11th Circuit's application of Florida law. I'm not
Is
seeing
there a state law that says you don't have the discovery rule?
there's not one that says you don't have it for unjust enrichment for a lawyer. There is unjust enrichment against your neighbor, against somebody you might have done business with, but not against your lawyer. And again, the federal court is applying 95
So lawyers aren't protected by the same law that everybody else is?
Sorry, lawyers?
Lawyers aren't protected by the same law as everyone else?
No, they're there to protect their clients. They're there as fiduciaries, and that's why there is a delayed discovery rule in cases against your lawyer, against your architect, against your CPA, and other trusted professionals. And again, the 11th Circuit is saying that professional malpractice limitations period applies to both contract and tort claims of any stripe, so long as they involve wrongful acts allegedly occurring in the course of a lawyer-client relationship. And that's what we're doing here. We said there was a relationship. It wasn't properly documented. It wasn't, that the fee wasn't there.
When did your client figure out that the kids ran off with the money?
Not until he started being told by Ms. White and her predecessor.
Yeah, when was that?
Well, we allege that 2020, he got the guardian.
No, I don't think you alleged when he would have discovered that there was a problem.
Well, it's not that there was a problem, it's that there's a problem with these lawyers, but we have alleged that plenary guardian was appointed on January 28, 2020, and prior to the appointment of that guardian, he could not have discovered the malpractice of defendants. Whether Captain Kilpatrick or somebody else were come up for it.
You just cited a legal conclusion. What are your facts?
My facts are, I did not know that this was a legal fee until he had a guardian looking out for him and
He needed to know, the statute of limitations would have started when he found out that his case was settled and there was money there. When did that happen?
To this day, if you ask him, somebody doesn't remember when the case settled, how much for it. But, I mean,
He wasn't found incompetent until when?
I guess right before January 28, 2020.
And from the other facts that I've heard, he was awake and lucid in between the time he was found incompetent and since the accident.
Times he was awake, Judge, and this is well beyond the four corners, but the point is that the other cases we talk about, for example, Downing versus Bain.
Didn't I find out something else about the facts of this case when we were talking about, when you had the other causes of action, where one of the lawyers actually went to him and got him to sign off on it?
Well, there was a lawyer that got him to sign
Yeah,
a release in favor of his son.
Yeah, when did that happen?
I believe that was towards the end of 2017. I believe that was in late 2017, Judge, that
All right,
release.
well, why wouldn't, okay, so at that point in time, when he signs off on the contingency, that Politis shouldn't have accepted from the son and the daughter, okay?
Wait, Judge, I thought you were asking when he signed the release in
When
favor
did
of
David Fox, didn't he sign off on something?
After the case was settled, they had him in the office, and he signed the contract, and the contract's undated, but it was sometime later on in 2017.
All right, well, why wouldn't that, at the latest, as far as the discovery rule goes, why wouldn't he have been discovered that at the point in time that he's sitting in the office with the lawyer, and the lawyer's telling him we settled for this much, and he signs off on it?
Because,
Why wouldn't that be the latest date that the statute of limitations starts?
because under Downey versus Bain, a first DCA case, the discovery of the legal malpractice claim is treated as a factual matter due to the fact that a layperson is not expected to understand the intricacies of the law. And he doesn't know that it's illegal. He just knows that they're putting documents in front of him to sign, and he's getting money that actually being sent to his daughter, but money's getting
Well,
sent
then
to
under
his
that
daughter.
scenario, then a layperson, the statute of limitations never starts for a layperson because they can just, at any time, just say, I didn't know what the law was, so therefore the statute of limitations never started.
Well, that's why it matters that he did not have the faculties of your ordinary layperson. If he were
Well, you only alleged that he was incompetent in 2020, right?
unless we've alleged, again, like I said, it's what's in our allegation, we've alleged that paragraph 22, he continued to, when he was belatedly executed a contingency agreement, he continued to have significant limitations upon cognition, memory, insight and judgment and still lacked capacity to manage his own property. Therefore, he could not have known that what he was signing off on was illegal and that the contract was void. So we've alleged that he continued to have these significant limitations. There's letters from Mr. Politis to the daughter and to Mr. Fouts that basically says, that he was incapacitated, unable to tend to his affairs when he was asked to sign a power of attorney, things like that. So, we really need to get into discovery here. I mean, I've laid out that he had those limitations upon his cognition, memory, insight, and judgment, and that, as not only a layperson, but a layperson with these problems, that he can't be expected to know that he has a legal malpractice case.
Didn't Mr. Guardiana go out of his way to get you information about what happened with Mr. Potts back then?
I don't know what you mean by out of the way, Judge. I mean, again, we're beyond the four corners of the complaint, but that doesn't mean that Mr. Fouts understands or comprehends that he's been, had a lawyer take a fee that's illegal.
All right, so I'll give you one more chance to tell me, in your complaint, where do you allege that, allege a standard of care that was breached by Mr. Politis?
As a standard of care matter, I allege in count one, legal malpractice under the theory of negligence.
No, I don't want to hear what your legal conclusion is, okay? I want to hear what facts you allege that claim that there was a breach of the standard of care.
Yes, sir. I allege that he breached the reasonable duty of care by, but not limited to charging a contingency fee rather than a reasonable hourly fee, and that he should have known that the defendant should have known that the fee agreement was void. And we allege that is a breach of standard of care.
All right. Mr. Partlow, he says that he gets used the discovery rule on unjust enrichment because lawyers, I guess, don't get the benefit of your case law that says that other people that are sued for unjust enrichment, the discovery rule doesn't apply.
So as I indicated before, the 95.11, as it applies to malpractice cases involving attorneys, applies to the claim whether it's brought in contract or tort. That would apply to an unjust enrichment or quasi-contract type claim. However, the factual allegations in this case are the attorney, however they said it, charged too much. The alleged improper act was related to the contingency fee
Actually, I
agreement.
don't think the allegation really is that he charged too much. It was that Mr. Fotz isn't the one that signed the agreement. He shouldn't have got, the kids didn't have the authority to sign on behalf of the father.
But the alleged
So
damage,
therefore,
the alleged damage is that he charged too much. That is the only alleged damage in this
I
case.
thought it was that it was an illegal contingency fee agreement because he didn't agree to it, and under that circumstance where you got a full contingency fee agreement, he's only entitled to his hourly rate.
That's the theory for the damage claim of, because he collected a contingency fee and was only entitled to the reasonable value of services, he received too much. The allegation in the complaint is that an attorney would have taken this on a reduced contingency, which notably Mr. Politis actually did. There's an allegation that he could have even found somebody to do it pro bono. The only claim damages are the difference in the fee charged versus what they're saying he was entitled to. The case law in Olmstead was actually cited in my motion. Case law says in Olmstead, the plaintiff must demonstrate there is an amount of damage it would not have incurred but for the attorney's negligence. There has to be an underlying mistake, negligence, improper, something that causes that underlying injury. We have no underlying injury here. Plaintiff has conceded that today. The only issue is the fee. Under the case law I cited, there is no legal malpractice claim for the fee issue. However they want to call it, whether it's the contingency was void, or it was void so they charged too much, or he was only entitled to a reasonably hourly rate, the alleged damage is the fee. The cases I have cited say that is not a claim for legal malpractice, which is why delayed discovery does not apply. So, back to your original question. Delayed discovery applies to a professional malpractice or negligence claim against an attorney, regardless of what they call it. Here, this is not, as a matter of law, a legal malpractice claim. Therefore, delayed discovery does not apply. The fact that my client is an attorney does not render every claim against my client legal malpractice. None of the cases cited, this is not it. So there is no delayed discovery rule. Additionally, as argued in the motion, any claim based on the amount charged at the time would have been discovered by a reasonable person at the time the fee was taken. Under plaintiff's theory of the case, a client of an attorney could bring a malpractice suit at any point in time, at that point where they determine, I charge too much. If I inadvertently type a 5 on my billing sheet today instead of a 1 for this hearing, under plaintiff's theory, I could be sued 10 years from now when the plaintiff just so happens to look at that bill. The reality is, the case was settled, the fee was paid. To the extent your Honor finds this is a legal malpractice claim, any claim under delayed discovery started to run at that time. But I don't think you get there. This is not a claim for legal malpractice. Under cases, Olmstead being one of them, Olmstead does not support the argument, as plaintiff indicated, that this is a claim. Olmstead had 2 counts. The first count was legal malpractice, and the decision says the neglect of the reasonable duty was not in dispute.
Why did you claim unjust enrichment?
In Olmstead, the second claim, again, is not named, but it says Olmstead alleged that the contingent fee charged by Politis, the attorneys, was excessive and illegal under Florida law. According to Olmstead, the contingency fee contract was void and illegal, and he sought the return of that fee. But if you look at...
Now, why was it void and illegal in that case? Because was the contingency fee higher than the...
No, I believe the court found that it was not void and illegal.
Oh,
It was
void.
proper in that case.
Oh, it was?
But, yes. But in evaluating the actual legal malpractice issue in that case, the court cites the same case law that I reviewed. The plaintiff must demonstrate that there is an amount of damages which he would have recovered but for the attorney's negligence. To be liable for malpractice arising out of litigation, the attorney must be the proximate cause of the adverse outcome of the underlying action. We have no adverse outcome here. The settlement Mr. Politis obtained, there's no challenge that was improper. The challenge here is to the attorney's fees. Continuing the issue in Olmstead, the court said, in this case, there's no dispute about the facts that Olmstead retained the Politis, that the Politis neglected a reasonable duty owed to Olmstead when they failed to invoke the statute as a basis for relief, and it continues. So in this case, the neglect of that duty was not even at issue. But in evaluating this case, the court said this is not. They alleged, or the court found that it wasn't malpractice as count 1, and that's the count where the court says no malpractice related to fees. And then they go to count 2, and they said, but in this other count, he's seeking return of the fee. And they ended up finding that fee was proper. But Olmstead supports, again, the position that a claim for legal malpractice cannot be based solely on the amount of the attorney fee charged by the lawyer. If there's an issue with that amount, it's either a contract issue or it's a quasi-contract issue, such as unjust enrichment. It is not a malpractice claim. So the delayed discovery rule does not apply. And here, it's undisputed that if the delayed discovery rule does not apply, this claim is time barred.
All right, what about let's not call it legal malpractice, but he's saying that there's an implied in fact contract. So he gets it signed off by the children, he didn't have authority to sign on his behalf. Settlement happens, before he, and the fee is paid, before, before this guy even knows anything's going on with his children and the claim. And, and basically the theory of that is he is representing Mr. Faust, but that under the ethical rules, he's only entitled to receive, since he didn't get Mr. Faust to sign off on it, he's only entitled to receive the amounts that he would get under his hourly rate. And therefore, they want the return of the balance. Now, I guess that'd be a contract claim, right?
Will be a quasi-contract claim, yes.
Well, not really a quasi-contract claim, it would be more implied in fact contract.
Some sort of implied contract, whether it's implied in fact, implied in law, quasi-contract.
Well, the law, yeah, the law would imply the contract.
Yes, there's some sort of implied contract.
And that under that contract, Politis would only be able to receive an hourly rate.
Under the case law, where courts have found a contingency void, the attorney is entitled to the reasonable value services, which is generally the reasonable hourly rate lodestar approach.
So let's say Politis didn't get his $105,000 at the closing of the settlement, and that was in escrow somewhere, and it was Politis suing them for his fee. He'd only be able to collect his hourly rate, correct?
If the court found the fee void,
See,
the
if this was,
contingency fee
like
void,
if we flipped the parties and you were on the plaintiff's side,
yes.
and they were on the defense side, Politis could only collect an hourly rate.
If the court found the contingency fee contract void, then I'd be here arguing he's entitled to the reasonable value of the services. He took this case or claim at a reduced contingency.
You say
And
that the reasonable rate was the 30%.
the reasonable rate for services was far more than 30%. He did this because Mr. Fouts was a law enforcement officer, and as he normally does, he took that claim at a reduced contingency. And that's what I'd be here arguing.
How many hours do you think you put in on it?
That I do not know. But it was not a quick open and shut claim, I can tell you that. We know that because the motor vehicle accident took place April 16.
How thick was his file?
I do not know how thick the file was. Contingency fee agreement was signed in April or May of 16, and it wasn't settled until March of 17. I do not know how many hours were put in.
All right, on an implied in fact contract, does the discovery rule apply?
If the claim is for legal
It's not
malpractice,
legal, throw legal malpractice out.
then the answer is no. The only time you get delayed discovery under 95.11 is under sub 4, I believe. B, an action for professional malpractice, whether founded on contract or tort. So this is not an action for professional malpractice. And so the delayed discovery provision that is only found in this section, 95.11 sub 4B, does not apply.
All right. Was your argument that it doesn't apply to lawyers because of that section that says when it relates to legal malpractice on your unjust enrichment?
Judge, my argument is
Is
95.
the only way you get the discovery rule is if you can call this malpractice?
No, Judge, because again, the Nussbaum case, Montero versus Nussbaum case we cited, refers back to 95.11 and apply the lure should have known to a claim for breach of contract and unjust enrichment. That's the statute they apply. So again, under 95.114B, a claim for professional malpractice, and that's the point, is that you can negligence is not the only stripe of malpractice. The typical legal malpractice, duty, breach, causation, damages is not the only stripe of
I
malpractice.
think you kind of missed my question.
Okay.
Pretend like Politis was not a lawyer. This had nothing to do with a legal claim.
Okay.
And you had an unjust enrichment claim and/or an implied contract claim. Does the discovery rule apply?
It does, because the discovery rule applies to anybody in privity, and that's strict privity or also this idea of an applied contract. Anyone in privity with a professional, i.e. 4-year degree plus some certification by the state that you're a professional, so it would apply to any claim by a client or equitable client against his lawyer, his accountant, his engineer. That's what it applies to. It applies for professionals, whether in tort or contract, and that's the point of the statute.
Even
Says,
if all it is a fee dispute.
even if all it is
It's
a
a contractual fee dispute is what you have.
Well,
You
we don't-
got a contractual fee dispute. What's that got to do with legal malpractice?
well, we've pled a void and illegal fee, but it has to do with legal malpractice because it's a claim for professional malpractice sounding in contract versus a professional malpractice sounding in tort. And the statute allows professional malpractice claims sounding in contract to have the discovery rule applied to it. So if Mr. Politis is a professional and he's in privity, either under an applied contract or an express contract with a client, he's subject to the delayed discovery rule. If he's not in privity, or if he just, he's operating something outside of a lawyer, outside of a professional's realm, then yes, you'd be entitled to the regular old 4-year unjust enrichment statute.
All right, Mr. Carlo, he says that a contract claim with a lawyer is enough to get you the discovery rule, it doesn't have to be negligence. What does your case law say about that?
The statute says an action for professional malpractice whether founded on contract or tort. The part you have to highlight there is an action for professional malpractice. All the cases cited by both sides, if I look at plaintiff's case, Matera versus Nosbaum, it's a...
I thought you said there wasn't any cases out there where it was after the fact and we had a fee dispute.
No, not, this case is not, no.
Do you have other fee disputes that says that that's not legal malpractice?
I have the fee
You got a fee
disputes.
dispute here.
I have fee disputes, for example,
Mr. Politis didn't follow, allegedly, Mr. Politis didn't follow the ethical rules.
right, and so on that,
So why can't that be under the realm of legal malpractice, even though it's not negligence?
so the first case I cited, it's a federal case, but it's Harris Hunt in Deer, PA versus Taylor. This is citing the Florida law, goes through the same general case law, and it says Taylor cites no case holding that excessive billing constitutes legal malpractice. In fact, none seems to exist under Florida law. It cites a fourth DCA case which says,
Well, you got more than excessive billing here. I mean, it is they're alleging that it's excessive. But you have, the allegation here is that he entered into a contract with people that didn't have authority and represented this guy without the proper authority. So it's more than just having an excessive
so
billing.
within each of those cases I've cited, almost uniformly, every single one has a citation to a case that says, and this one happens to be Presley versus Farley, it's the first DCA. A violation of the Florida rules of professional conduct governing a lawyer's responsibilities neither creates a legal duty on the part of the lawyer nor gives rise to a cause of action. So the fact that there's an ethical issue is irrelevant. It makes no difference to this claim. This claim is, I as the plaintiff, I should have been charged some amount of money, yet I was charged more than that. I'm entitled to the difference between those two numbers.
Isn't he entitled to pick his own lawyer? He didn't get a chance to pick his own lawyer, did he?
He was in a coma at the time the original contingency fee was signed. He was not in a coma at the time it was settled. He was not in a coma at the time the settlement was paid, or the time that the contingency fee was paid. There's no allegation in this case related to the issue you just addressed. The only allegation in the case is that the contingency fee
Well, it's not
agreement
an
is...
allegation, but it's it's one of the circumstances that you get from the facts that are alleged.
He was in a coma at the time the contingency fee agreement was signed. Yes.
Son and the daughter came and signed off for him without having a power of attorney or without getting guardianship.
Correct.
Right. So, he didn't get a chance to pick his own lawyer.
And there is no allegation whatsoever that the
So who cares,
services
who
provided
cares
by
that,
that lawyer.
I mean, and, you know, who cares that, you know, no, he wasn't gonna be able to collect more than $350,000. He didn't get to pick his own lawyer. Isn't he entitled to that?
One, it's not an issue. Two, to state a cause of action,
Why would that be legal malpractice?
because every case
I mean,
I've cited
You get
says,
a lawyer forced down your throat, why wouldn't that be legal malpractice?
because every case I've cited says the plaintiff has to allege and establish a causal connection between the alleged facts the attorney, alleged acts, negligent acts the attorney committed, and the alleged damage suffered by the plaintiff. Here, what we have heard plaintiffs say is we are not challenging the amount of the settlement. That is not at issue. Every case says you have to have a causal connection.
He's disputing the amount of the settlement that he got.
He's disputing the amount of the fee that was
He's
charged.
not disputing the overall amount, he's disputing the amount of the settlement that he got. If he ever got it off of his children.
Well, that's not how it's framed in the complaint.
No, I mean, you can certainly read the complaint that way, though, can't you? All right, here's what I'm gonna do. With the underlying act, Mr. Partlow, I mean, I agree with you. This is not a traditional legal malpractice type of a case. It certainly isn't negligence. So as to count one that sounds in legal malpractice for tort/negligence, I'm going to grant you motion to dismiss with prejudice. It as to count two for the implied in fact contract. Count three, the quasi-contract. And count four, well, the breach of the fiduciary duty. And count five, the unjust enrichment. I'm not as confident as you that the 50 CA might not be able to pull the underlying facts from here and say, yeah, it's not a simple fee dispute. So based on that, I want to see the facts relative to the discovery role and let the plaintiff have an opportunity to do discovery about that. And so I'm going to deny the motion to dismiss as to counts 2 through 5. So granted as to count 1, because there is no negligence alleged, and deny it as to count 2 through 5. How much time do you need to file an answer in affirmative defenses?
14 days, I could.
All right, give you 20.
Okay. And
I'm
Judge,
gonna give him 20, Judge, so.
All right.
aside from depositions, there have been tens of thousands of pages produced in this case, so we're not going to need a extended case management schedule when that day comes.
All right. Actually, let's go ahead and talk a little bit about that then. How old is the case now? Over a year old. Actually, we got 18-month anniversary next week, huh?
That's about right, Judge.
All right, so the case is on time standards at the end of next week. So when will we be ready for trial? I won't send out the trial order until we get an answer in affirmative defenses, though. It'll only be a projected trial date until then, and then it'll be a real trial date after that.
I would think no sooner than January, based on the number of depositions that will be required as to the discovery issue, because it hinges on Mr.
If I give you January, bar any real emergency, you probably won't get into the continuance. If I put it out as late as January, barring some kind of an emergency or something else going on, that would give you priority in somebody else's courtroom or something along those lines, I would probably be unlikely to give you a continuance. Plus, I need your summary judgment filed in enough time that we can have it heard before January as well.
Right.
Okay, Mr. Bradstreet, January okay with you?
I'm fine with January, Judge.
All right.
Excuse me, Your Honor, I hate to interrupt.
Go ahead.
Francis Carroll, I represent Mr. Politis, obviously, the law firm. I did want to bring this to the court's attention, is that Mr. Parlow is retained by the insurance carrier. There's currently a declaratory judgment action filed in federal court. I know he couldn't speak to this, but that may interfere with the timing of this action, depending on how the issues and what the discovery is going to turn out to be in the federal action.
Well, that's interesting. You know, we've had a little bit of a discussion about that. You know, I've always assumed that federal judges trump state judges. But you know, if you look in the law, there really isn't anything that says that. And there kind of has always been a little bit of a understanding, at least with our circuit, the local federal judges, that there was no understanding that the federal cases get, you know, trump the state cases. Not that I want to test that, but we'll wait and see what happens when we get there.
The reason why I raise is because, not to question the superiority of this court versus Judge Mendoza, but there may be
Oh,
an
it's
issue.
Judge Mendoza?
It is.
All right. He's an old state colleague.
We is from Putnam County, and but it may affect the whether or not counsel will be available pursuant to the request or the rulings of on the coverage case, in which case we
You know,
would.
when people have when attorneys have conflicts with other judges, the judges pick up the phone and talk to each other. I'll be glad to talk to Judge Mendoza.
I just didn't want to get jammed up, I mean, in the vernacular and say, you know, we have to go ahead and defend ourselves because.
I mean, I very, very well may defer to Judge Mendoza, but I'd probably pick up the phone and talk to him first.
Thank you, Your Honor.
All right,
Thank you, Judge.
okay, anything else we need to talk about?
Nothing further.
All right, we'll see you next time.
Thank you.